2016 at Common Lane in Cannock. An event was taking place, and we say that the people who were running that event, MR events, failed in their duty to properly ensure that their health and safety practices were adequate. So much so that as a result of their failings, their criminal failings, an individual suffered a fracture to the hip. This is a business with employees who have responsibilities. This is a business which should have known what it was doing.
Mr. Basharat, do you wish to take a religious oath or do you wish to affirm?
I wish to affirm, please.
Please keep your voice up and direct your answers to the judge and repeat after me. I do solemnly.
I do solemnly.
And truly.
And truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you, Mr. Basharat.
If you're giving evidence, always, if no one's asked you and you wish to affirm, tell them to use any other religious text apart from the New Testament. Tell them there is no distinction between people who swear an oath on different religious texts or those people who choose to affirm. The important thing is that there is a solemn promise upon whichever way appropriate for that individual witness that they're going to tell the truth.
If you're a diabolist, be a bit careful because it's difficult to find a goat in central Birmingham. Sorry, I'm joking. Carry on, really.
Okay, can you give your full name to the court, please?
My name is Mohammed Basharat.
Is it correct that you're one of Her Majesty's Inspectors of Health and Safety?
That is correct.
Your Honour, this is at pages 17 in my bundle onwards. A number of statements from Mr. Basharat.
Yes, I think it's page 16 in the court bundle.
I think you are there. There's one statement running over several pages rather than...
Yes, Mr. Campbell.
Can I leave?
Yes, you... Well,
On what?
Basics.
Members of the, what would happen, and to be fair today, we haven't had much time this morning, if I would say to him what he can and can't lead on. It might be that I took a very hard line, nothing. And then he'd have to establish how everything from the date upwards.
Can we explain?
Yeah.
We know what leading is. Basically, if I say to a witness, are you an inspector for the United Kingdom Safety Inspectorate? That is a leading question because you're telling him what the answer is. If I say to him, what are you, what is your job? That is not a leading question. And so, basically, unless it's agreed, the prosecuting barrister is not allowed to tell the answers to the witness. If they're not contentious, let's not waste any time over it, if they're not in dispute. But if they are in dispute, then you can't ask a leading question.
A leading question is if the answer is yes or no. That's a leading question.
The rule of thumb is that if there is evidence of controversy or evidence which goes to the issue, the offence which is charged, you shouldn't lead. All of the stuff, peripheral stuff, you should be allowed to lead on.
Page 1, date, time and place.
Is it correct on 15th of February 2016 you received a notification of an incident?
That is correct.
Was that under the video reporting regulations?
Yes, it was.
Are you familiar with those regulations?
I am.
Did the report, as you first saw it, was it a properly made report?
Yes, it was.
As a result of receiving that report, what did you do?
I instigated an investigation according to UK Safety Inspectorate procedures, which led to me visiting site and conducting a formal investigation.
Did you telephone anybody?
I spoke to the individuals on the F2508. I spoke to Mr.
Sorry, stop there. You spoke to the individuals on what?
On the F2508, the notification
Sorry.
form.
I know that you're used to
Yes.
jargon, and I know that you're used to nomenclature. Who did you speak to?
Spoke to Mr. Woodford,
Right. Who was Mr. Woodford?
the MD of the company MR Events.
Who are MR Events?
MR Events are the company that were laying on the or managing the actual event in question.
Who made the RIDDOR notification to you?
Mr. Woodford.
Did you have cause then to attend at the site?
Yes, I did.
What time did you attend at the site?
I don't recall the exact time, but it was after the actual incident had occurred.
Well, we know that it must have been after the incident occurred, otherwise you wouldn't have attended.
Yes.
Can I lead? Is it correct that you attended at 2 p.m?
That's correct.
Upon arrival at the site, did you see anybody?
Yes, I saw a number of individuals.
Did you speak to anybody?
Yes, I did.
Who did you speak
I
to?
spoke to the health and safety advisor.
And what was their name?
Their name was
Page 18.
page 18.
One, please. Yeah. Mrs. Hugh.
That's correct, Mrs. Hugh.
Miss Hugh. What did she say to you? Did she say anything to you?
She advised me that the incident had occurred.
What was the details she gave of the incident?
She gave me details that an individual had driven a buggy onto site and struck the injured person, and the injured person fractured a hip and was taken away to hospital.
As a result of what she said, did you do anything?
Yes, I then investigated. I took a number of statements from individuals involved with the incident, and I also took copies of a number of documents.
Third paragraph down on that statement. Sorry, we'll use a bit of leeway here.
So what page are we on to now?
What else did you do once you first spoke to Ms. Hugh?
Okay, I also took a number of photographs of
No,
various...
take you back. And take this slowly. Paragraph 3. Statement dated 30th of April.
Page 17.
Page-
Page 18 on mine, 17 on yours. Could be 19.
17.
Right. Once Miss Hugh
Yeah.
gave you the information, what did you do?
I then made entries into my notebook in
Right.
respect...
Do you have that notebook?
No, I don't.
Does everyone get why that's important?
Stand up.
Because if David doesn't establish he's made a note, because I'd like to refer to it, I'm going to go, well, what note? We haven't heard about any notebook. What do you want to do? Some crib sheet? No. And he's on a, I'd be saying, well, he's on a, hasn't proved that he made the note of the contemporary. That's straight as soon as he possibly could after it. He might have been spoken to by his boss. Make a quick note of it all. Get my poor chap in trouble. So I'd object to it. In fact, we don't have a notebook, so it's not going to work anyway. But the point being is, that's why David was doing it. He would not be able to lead like that, because obviously I would be saying, that's leading, you can't refer him to a statement. But we're in this environment, and to be poor and fair to the witnesses, this is not reality, so he's not working from memory. All right.
And also, if this was a longer trial, you'll see here that Mr. Basharat has made a note of what she sent to him in his notebook. You'll also note that it doesn't appear in the evidence that he ever offered Mrs. Hugh an opportunity to sign that notebook as a true and accurate record of the conversation. Now, if you're on the receiving end of an investigation and you are asked by an investigator to sign a notebook, read what they have written down. It will not do you any good if you refuse to sign, or anybody whom you're training, whatever you do, don't tell them not to sign it. Because if they say, I'm not going to sign it, the notebook will say, I offered them the chance to sign it, and they refused. If you or anyone who you're advising is shown an officer's notebook to say, is this true and accurate, get them to read it. And sign it if it's accurate, and if it's not accurate, for them to say to the investigator, no, you missed out what I said. Yeah? And also, first and foremost, in the nature of any business, there are people who can't read or write to the same standard as, say, Gavin can. You need to instill in the people who you're training and the companies that if they have a problem with reading and writing and they're asked to sign something, that they should explain to the person, I have a problem with reading and writing. Or English is not my first language. Because the notebooks and these sort of little things, which are done pretty soon after the incident, are the hub of the case. Why is it the hub of the case? Because if you're sat there on the jury as you are today, are you going to be more likely to believe that which was done so soon and near to the incident, where people will say, no, this is what happened, or 3 years down the line when someone goes, oh, I just remembered, actually it went this way. So that is really, really important. And if it isn't written down, it didn't happen. So it's important for you to pass on to the people that you train within your workforce that there's nothing to be scared about. And there's no harm in them saying, no, that's not the full story I've just given you. You'll see in court, right? Not in this case. First question to the police officer or the investigator. How long did you speak to Mrs. Hugh? 10 minutes. Can I have a look at your notebook? Yeah. 1 page. One small, very tiny page.
If at all.
So straight away it's, sorry, you were there talking for 10 minutes and you've made 6 lines of notes. What were you talking about? And the defence will then go on to show, well, what's missing? Because what also happened is basically the spin has started from the investigators to put a light on it in a way which is for their purposes. Because everything an investigation does is an evidence-gathering exercise. They are not your friend. Google is your friend. They are not your friend. Okay, turning now, Mr. Basharat. Did it come to time when you saw the buggy involved in the incident?
Yes, I did.
Can you describe the buggy?
Buggy,
You can describe the buggy as green, yes?
green, yeah, and
Yellow stickers on the
yellow
side.
stickers, and there's a photograph in my exhibit bundle.
Okay, could you be so kind, just because we're flicking through, to show me where the photograph is in the
Okay,
bundle?
it's on page number 30 on my bundle,
It's a
maybe
picture
30.
of a buggy.
Yeah, page number 30.
Yep, a John Deere.
That's correct.
31 or 30 or 32, depending upon
Yes.
which bundle you've got.
People don't know what a buggy looks like.
Okay. Once you saw the buggy, what did you do?
I took photographs of the buggy and I also sat behind the wheel and used some of the controls whilst it was standing still.
Why did you do that?
I just wanted to check that the vehicle was actually operational.
Are you qualified to do so?
I have a certain level of qualification in that I have a driving licence and I drive a car, and therefore I am able to examine the rudimentary controls on a vehicle to assess whether or not they're actually working. But
Are you a mechanic?
But I'm not an expert.
Are you a mechanic?
I'm not a mechanic, no.
You ever worked for John Deere?
No.
Okay. You then correct that you walked around the site with Mrs. Hugh. Ms. Hugh?
Yes, that's correct.
She explained the site layout.
Yes.
You went through the 2 different routes within the site.
That's correct.
You observed a number of signs saying all vehicles past this point must have a banksman.
Yes, I did.
You then went back to a production office. Did you then go back to a production office?
I did indeed. I went back to the production office.
Did you have a conversation with her?
I did.
What was the nature of that conversation?
Okay, we spoke about various things around how the site would be managed. We talked about site inductions and site risk assessments.
Did you then take any documents from the site?
I did. I took a copy of the site risk assessment and the site induction.
And do you produce those as exhibits today?
I do indeed.
You are now prosecution exhibit 2. Buggy will be number 1.
Yes.
Okay. Exhibit MB4 will be my site induction, and exhibit MB5 is the risk assessment.
Okay.
So I've got the risk assessment, I think, at page 34, is that right?
Indeed, Your Honour, or thereabouts.
Yes, 33 leading onwards.
Couldn't find it in mine, but
And I've got,
It doesn't matter, Your Honour, it was never followed.
very well.
well, that's a comment. Thank you. Your Honour, please control counsel. Or unless he wishes to give evidence, in which case perhaps he should be sworn.
Okay. Okay, moving on. Did you then speak to anybody else? Page 20 or 21 or 22 in your bundles.
Yeah, I went to the security office and I spoke to the security officer, Mr. King. And I also spoke to the security officer, Mr. Greaves.
What was the nature of the conversation which you had with them?
Mr. Greaves and Mr. King explained to me what had happened on that day that they were aware of.
What did they say to you?
Mr. Greaves explained that he had seen the actual incident take place, at which point I took a statement from Mr. Greaves.
Did there come a time then that you received a report from Specialist Inspector?
I did indeed. The Specialist Inspector produced a report and told me that the buggy was in full working order.
And that it met all the specifications and was suitable for use on the site?
Yes, that is correct.
No issue on that. Your
No.
Honour.
On the 2nd of March, did you then have an appointment with Mr. Woodford?
I did.
What was the nature of that conversation?
We had a conversation in respect of the company health and safety policy. I took a copy of that health and safety policy from Mr. Woodford, using my powers under Section 20 of the Act.
Did there then come a time when you interviewed Mr. Woodford under caution?
I did. It was a short time later that I invited him to our offices as a representative of his company, and he was interviewed under caution.
And that was on the 23rd of April.
That's correct.
Ladies and gentlemen, 75. Now, any questions about what's gone on so far at all? I know we're speeding through it a little bit, but... Sorry?
Well,
I sit there, I listen to him, I let him get away with a bit, and then if he's, what I'll do is you'll hear counsel just say, leading. If he doesn't take the hint and stop it, I'll get to my feet and go, Your Honour, the witness is being led, would you please intercede? That is a leading question, as of the last 6 been. Perhaps we could get back to asking the witness for his evidence rather than my learned friend giving his view of accounts.
And sometimes
Or
it's
words to that effect.
just the defence counsel just reminding the jury that they're still there.
You can use it, it can be quite useful. You can sort of remind people that also that if it's getting a bit too pally, just throw it in and say, hey, you know, it's supposed to be over here, you know, back to me.
It's a massive grey area. The thing is that you know what the line you'd never cross. But if you as witnesses don't worry yourself about that. But the important thing is that if you are giving statements to either the solicitors on behalf of your company, or if you're giving statements to the health and safety executive because you've been a witness or you're a manager. I had to give a statement once to the police. I was living in London. Guy runs down the street. I saw him push over a woman, realised he nicked the handbag. I stuck my leg out. He fell over. I jumped on top of him with my weight. He ended up getting nicked. Go and see the police officer. One thing I didn't tell the police officer was what I did for a living. Typical copper. Tries to tell me what should be in the statement. I said to him, no. This is my statement. Yeah? Warts and all. Now, the nature of human beings is that you want to be liked, that you want to please people, that if a member, someone in authority or the solicitor for your company is asking you questions, you want to say the right thing. No, say the truthful thing. If you don't put it in your statement, and it ultimately comes to court, you can bet your bottom dollar that the issue is going to be raised in your statement, because what lawyers look at is never what's in statements, because we know that you don't lie. What we look for is what isn't in the statement, because people are sometimes economical with the actuality, because they're embarrassed, because they don't want to admit that they made a mistake.
Alternative facts.
I said the fact. And it's usually little things like swearing. When I arrived at the scene and saw the mangled body, what did you say? Oh, golly gosh. No, you went, fucking hell. No one's going to worry about you doing that. Because courts are real places. And it's always a shock for the jury when you see the barrister using a C word or the F word or the B word. Because we use the words which were actually used at that time and at that place. So if you swore, if you did something which later you wish you hadn't done, you know, put it in your statement. You're not going to be prosecuted for it. You get prosecuted because you actually have lied in your statement. And what we look at from a lawyer's point of view, and what investigators look at, is what's not in there. And when there are the gaps, that's what causes more of an investigation, which costs your companies more money, you more time, diverts you from things. And often it's, oh, I didn't think it was relevant. No, tell them initially. Because your best chance is to cut off these investigations early and save on legal fees, save on time. But the only way you're going to do that is by being candid. And where that ends up you being, whether you're guilty, your company's guilty of offence, so be it. But get the truth out and get it out quickly and easily, because it's the lie which gets you. The National Security Advisor hasn't had to resign because of speaking to the Russians. That's too Bob. It's lying to the Vice President. Nixon wasn't brought down because of a 2-bob burglary at the Watergate Centre. He was brought down because he lied about the 2-bob burglary at the Watergate Centre. It's the lie which gets you. And people don't get it. You come to court and time again, we see it. It's that little bit of a lie. And even if it's a minor matter, what defence do is use your lie over the minor matter to cross-contaminate your evidence over the real serious things. Because if you're prepared to lie about something trivial, the other side will say you're prepared to lie about the important things as well. So that's the way it goes. Now we turn to interview 75.
74.
74, 75.
Do you want to take it as read, David, because we're running
Yeah,
out of time?
we'll run out of time. We'll take it as read. An interview under caution. The questions are not evidence. The answers are the evidence. If more than one person is being interviewed from a company, the interview is not evidence against the other person until it comes to court and that person gives evidence themselves in their own defence. The way it's done at trial is this: the prosecutor will always read the answers of the defendant, and the witness for the prosecution will read the questions which they've asked. The reason for that is to stop a snarky police officer or investigator using different type of voices to try and put some sort of spin upon the answers which the defendant gave in interview. One thing to notice here: if you're ever interviewed under caution, or any of your employees or whatever interviewed under caution, straight away your solicitor should have said around to them after the second question, can you explain what the caution means? And the solicitor should have said, that's not a matter for this individual. It is for the investigator to be satisfied that the person being interviewed understands the caution, not for you being interviewed to give some quasi-legal explanation about the caution. This is asked time and time again by poorly trained investigators, basically because they don't understand the caution. Yeah? No, your solicitor should be saying no, not a matter for them. Yeah? And if the investigator is not satisfied that you understand the caution, they shouldn't be interviewing you in the first place. Quickly on this, what's a voluntary attendance? Voluntary attendance is this: you turn up voluntarily, you're not under arrest, you can leave at any time. However, if you do leave at such a time, which then could either interfere with evidence or interfere with the prosecution, then they can get somebody to arrest you. So your best bet is you invite the voluntary attendance, go along. It's a beauty contest. When you're on a jury, oh, they went along willingly. Don't fall into the trap. This one is, oh, I don't need a lawyer. Yeah? They're not your friend. This is an evidence gathering exercise. If they had enough evidence before they interviewed you, their duty is to consider it and to charge you with an offence, or your company. They only ask questions in the interview to get more evidence to support charging you. So it's up to you, in consultation with your lawyer, to decide, do I need to say something now because it's actually going to help me? Yeah? Or do I even bother turning up for it? Yeah? They want you to incriminate yourselves.
It's two important points there. I've got to say that Dave's absolutely right. There is, under PACE, the Police and Criminal Evidence Act, if they have enough evidence to charge, they have no right to interview you. So your solicitor can just simply say, have you got enough evidence to charge to the investigating officer? And if he says, well, yes, thank you, goodbye. Under PACE, you've got no right to interview. But, as David says, you might want to get your side across, so you've got a record of it from the very start, before the charge has been put. Now, the important thing is, you don't have to do it in this clumsy way. There's nothing wrong with taking in a prepared statement and saying, I want to read a prepared statement, reading that statement, and then going, no comment. There's nothing wrong with that. You still get your side across, But you don't have to do it piecemeal and hope the police officer or the investigator is going to ask the right question. They might not, because they don't want to hear your answer. So think about the approach to it. But whatever happens, you wouldn't try and take out your own appendix. You wouldn't try and rewire your own computer. Why do people think they can conduct interviews without some legal advice? I never understand it, and I have seen too many cases where the prosecution would not proceed but for the answers given in interview. Think about it. You've just convicted yourself or your client. So it's that important. Anyway, the other thing to note is it says here there are selected extracts at the top. First thing you'd want to do as a defence is I want to see the whole transcript and listen to it to make sure it's an accurate rendition. Well,
This interview would never be played because there's so many inaccuracies and bad questions and legal and badly conducted interview that you're never allowed to take because you couldn't edit it in such a way. Anybody got any questions about the interviews or anything like that? No? Okay. If you'd like to wait there, then maybe some questions.
Yes, Mr. Collins.
thank you, Your Honour. Mr. Bashard, I see that you have been in post some 10 years, is that correct?
That is correct.
You must have conducted a number of investigations of this nature.
Yes, I've conducted a number of health and safety investigations, but not of this nature. This will be the first one for me.
First one.
Yes.
Are you aware of how important it is to not only get the right evidence, but to present that evidence?
Yes.
Do you think you've done everything you should have done and could have done in this case?
I believe so.
There's nothing you think is missing?
I do not know, I do not believe so.
Well, let's start with first principles. You were called to the site and you conducted an investigation as a result of an accident that had happened. Is that right?
That's correct.
And let's start from first principles. Did you investigate the health and safety record of MR Events Limited?
No, I did not.
You didn't check to see if they've had any previous problems?
It was not relevant at that time. I'd been called to site to investigate the incident. The incident itself at that time was not relevant to any previous history that the defendant may have had.
Or since?
Was that a question, Mr.
Was that a
It
question,
was
sir?
indeed. Have you investigated it since?
Yes, I have.
And are there any previous problems?
The defendant does not have a criminal record.
Has he had any previous problems with health and safety?
Not that I'm aware of.
Well, you investigated it, didn't you?
Yes, the investigation that I did not show anything else up to the contrary.
Is your answer then no?
My investigation did not show anything else up to the contrary.
Well, was it a thorough investigation?
I believe so.
Well, let's move on. Did you then look at the company's health and safety manual?
I looked at the company's health and safety policy, and I've exhibited that in the bundle.
Yes. I think we find it at page 46 or thereabouts. It's your exhibit number MB7, is that right?
That's correct.
You've been through it.
I have.
Is it good?
So, Your Honour, is it good?
Does it fulfil the statutory requirements? Does it stand up to scrutiny? Does it fulfil the function for which it was intended?
How many questions at one time has my defendant have asked you, Your Honour? I think that's counted 4.
Yes, they all have the same
If,
answer, Your Honour, and they're all the same question.
If you'll allow Mr. Collett to ask the question and Mr. Bashard to answer the question, then perhaps we'll get an answer, Mr. Campbell.
Thank you, Your Honour. Mr. Bashard, did you understand the thrust of my question? Have you had an opportunity to look at this particular policy, and is it fit for purpose? They are one question.
When I examined the policy, I found that the defendant's company had written an acceptable way of managing the specific risks that relate to the operation of the buggy on the site.
So, yes. It's acceptable.
Yes.
Ah, there we go. A straight answer. Good. Did you then go on to look at the risk assessment that had been conducted on this particular site?
Yes, I did.
And was that acceptable?
Yes.
So the company has a basic health and safety policy that is acceptable, and it had conducted an adequate risk assessment on this particular site. Is that right?
Yes, those are both two of my exhibits into the company's health and safety management system.
We have Ms. Hughes, who's an independent health and safety advisor employed by the company, don't we?
My understanding she is, yes.
right? And in your dealings with her, have you found her to be a competent person?
I found her to be a competent person, yes.
So we have a fit policy and a fit assessment. As part of that assessment, there was to be an induction, wasn't there?
That's correct.
And did you look at the induction?
I did.
And was that fit for purpose?
Found to be satisfactory.
So far, MR Events Limited have ticked, in the colloquial terms, all the right boxes, haven't they?
Yes.
Could you turn up a copy of the site plan? I think it's the back of your exhibit NB6. Although that's already been exhibited, Your Honour, I think the site plan, ladies and gentlemen, page 43 or thereabouts, could form a separate exhibit because it's something to which I think we were referring on a number of occasions. Perhaps if...
Page 42.
I think we're up to exhibit 3.
Exhibit 3, yes, indeed.
Well, then, ladies and gentlemen, if you're in the witness box, make sure you've got one of those with you. And when you hear exhibit 3, write it in the corner, because then you know what it is. If you've got about 20 exhibits in front of you, and someone says, could you now look at exhibit 6? Instead of looking flustered, you can quickly go to the right exhibit. Just a quick tip. Very powerful weapon when you're giving evidence. Anyway, right. Now then, Mr. Basharat, this is the site plan that you've exhibited. Just have a moment to look to yourself. Does this roughly concord with the layout that you found on the 15th of February when you attended upon the site?
Yes, it was.
Now, in opening, my learned friend said that, and I quote, apart from it's not bog standard, he said that, of course, protection to members of the public. When you visited the site on the 15th, how many members of the public were present on site?
Just the employees of the company who were working.
That's not a member of the public. How many members of public? So not employees, how many members of the public were present?
The site wasn't open, so no individuals were on site at that moment, no members of the public.
Right, just pausing there again, sorry to break the wall again. Do you remember what I said about listening to the opening? Whether David meant it or not, he mentioned safety to members of the public. There you go, just throwing it straight back in his face. How many members of the public present? None. You're the jury. What does that make you think? What's he going on about? Anyway, let's move back to back into scene, as it were. Mr. Basharat. Right. So this is the site layout. Now, talk us through this, where you came in. Which entrance did you use? Was it the entrance to the site?
Yes, it was the one close to the production office entrance to the site, yes.
And here, by the way, you would give the jury, if they hadn't already got one, copies of the plan so they could follow it. And again, for the sake of argument here, everyone's got one, but what you would make sure is that all jury members have got one. Don't keep them in suspense. And for the sake of a one-page document, kill the odd tree, make it 12 copies, not 6. Well, personal bugbears, I'm going to share everything. Anyway, sorry, Mr. Becker, back to the scene. So, you came in through the site entrance. I think we can all see that in the bottom left-hand corner of the site. Is that right?
That's correct.
Were you on foot or were you in a car?
I parked my vehicle, I was on car, I parked my vehicle off site, and I then walked onto site.
So you walked onto site. Who was the first person that you met?
It was one of the security officers.
And what did he say to you?
He then showed me the way through to the production office.
So did he ask you for an identification?
My identification was around my neck. He did not ask to see it, but it was there for him to see.
Did you ask to speak to a particular individual?
I recall asking to speak to Mr. Woodford, I believe, and I was directed towards Ms. Hugh, the Health and Safety Advisor.
So, you asked to speak to Mr. Woodford, and you were directed to Ms. Hughes?
Yes.
Why?
I cannot recall.
Well, why didn't you say, well, that's very nice, I'd like to speak to Ms. Hughes in due course, but let's start with Mr. Woodford?
Well, I wanted to be on site speaking to somebody who can inform me about the investigation. Not being able to see a particular individual should not have stopped my investigation, and it did not.
No, you wanted to go onto site to speak to somebody about the incident, I accept that, but you spoke to an independent advisor who is not employed by the company who is in control of the site. Is that your usual investigation technique, Mr. Basharat?
My usual technique is to go onto a site and be taken to the scene of the incident with a view to trying to ascertain how the incident occurred. Whom takes me to that site is frankly irrelevant.
Is it?
It is in that particular context. I was very successful. I was taken to the site of the incident.
So in your view, just the members of the jury, it doesn't matter who takes you there, the small boy with a sticky hand says, come and have a look at this, that's all right for you? Or do you want to speak to the person who actually has control of the site?
There were no members of the public with sticky hands on site to take me to the scene, sir.
I'm sorry, I was looking from the prosecution opening. So, is it something that you never, ever joke with a barrister, will have you?
Sorry,
So,
sir.
in other words, your serious investigation of this incident involves speaking to somebody completely unrelated to the company, and you didn't ascertain where the managing director was, who you've been directed to speak to.
The individual was related to the incident. They were heavily involved in producing all the health and safety management systems that we believe
did you know
was
that?
satisfactory at the time.
How did you
Wait,
know
don't
that?
interrupt, please, Mr. Collett.
Sorry,
Mr. Beshart was...
I spoke to an individual who was producing the health and safety management system, who were extremely well versed in what was going around on site, and that led the investigation to progress to find that actually, you know what, even though they had perfect or satisfactory, as I've described, health and safety management systems, they didn't fulfil them.
They had perfect systems. Your words are meant to
No,
be.
forgive me, I then corrected myself. I said satisfactory.
Yeah. Well, what was wrong with them?
They said they were satisfactory. What more would you I'm afraid you're going to have to rephrase your question. I just don't know what you mean.
I think the jury got it. If you didn't understand the
What, that
question,
it was
don't worry.
satisfactory? Yes, of course they understood that it was satisfactory. It complied with the legislative requirements. Would that be helpful, sir?
So you spoke to this woman who you say had produced all the information in these various documents that you had yet to see, I presume.
No, I had not seen them until it was brought to my attention as part of the investigation.
So why did you speak to this? She could have been anyone. How did you know who she was?
Forgive me, sir, if you were looking for me to say that she's a health and safety expert with lots of knowledge, I will concede that. She was aware of what was going on site. She was heavily involved with the production of the health and safety management system. That was the same management system that the defendant failed to comply with.
Well, you say that he failed to comply to it. The members of the jury might think that's their job. Let's see if we can get what your evidence is, Mr. Basharat. You say that these systems were in place and that you went onto site and you spoke to this woman who was, I think you said, was a very competent health and safety advisor, and then she took you around the site.
Correct.
Ah. And where did you go first?
I was taken, as I've explained, sir, to the scene of the incident.
So you walked straight into the scene of the incident?
I don't recall completely exactly the timeline, but I recall clearly being taken to the scene of the incident to conduct my investigation. I do believe that is correct.
So when you took all these photographs of these signs and things, was that on the way into or the way out of the site?
That was during the investigation. At what point was irrelevant because it was actually on the site. It was on the entrances and the exit points around the site, around the traffic routes. So, quite frankly, it was during the investigation.
Okay, Mr. Rapp, which way did you go in? Let's have a look at the map. You've got Exhibit 3. Were you taken through the entrance? We can see entrances to the field to the north or to the south?
I was taken through the entrance to the site as marked on the plan next to the site production office, and I recall during my investigation of going around seeing all the exits and entrance points and noticing that they all had signs.
I am going to stop you there. I know you've been told probably that you can keep going as long as you like, but you say the one closest to the site production office. Are you talking about the entrance to the pedestrian route, which is adjacent to it, or are you talking to the entrance to the field to the north or to the south?
I am talking about where it says on the plan, marked to the east, next to the site production office, where it says entrance to the site. That is where I went, and on the left of that site, you would see where it marks security office. That's where I was stopped.
Yes, we've got you there. Now where'd you go?
Went to the site production office.
Yeah, then where'd you go?
Yes, and then through where it says entrance to pedestrian route, which was the shortest route to the site of the incident.
Yes, but that only gets you into the pedestrian way. You then have to walk north to the entrance that's on the west of the site as we look at it, or south down to the southern entrance. Which way did you go?
Yes, I don't recall. But what I will say is, as part of the production of this plan, I was taken around and I saw all the site's entrances for the vehicles and the pedestrians, and that's what led me to take the photographs and take the view that the signs were present on all those entrance and exit points.
What else was at those entrance and exit points? Just signs?
There was traffic barriers or pedestrian traffic barriers to prevent pedestrians just walking straight onto the site. So we had pedestrian barriers left and right, and we had open access points marked as vehicle entrance and pedestrian entrance.
Anything else?
Forgive me, I don't recall.
Well, for example, was a large man saying, stop?
No, the large man, as you refer, was at the site entrance to prevent members of the public coming on without authorisation.
You interviewed Mr. Greaves amongst others, weren't you?
Yes.
Do you recall him saying that his job was to make sure there was no unauthorised entry and access by any vehicles that did not have a banksman?
I vaguely recall that.
You vaguely recall that?
Yes.
This is a security that is important to the health and safety of the users of the field.
Yes.
The man standing at that entrance is critical to ensure unauthorised access, it does not occur. Agreed?
Yes, I would accept that.
Was he there?
I believe, I don't recall. You'll have to ask Mr. Greaves when he gives evidence.
This is a quite important point. What the charge has been put before us is the fact that the company failed to implement its own safety, security, health and safety policies. Part of the induction and part of the risk assessment, including having people, banksmen, to control, as it were, vehicles on the inner field, i.e. where they came in conflict with pedestrians. Where do I see your investigation, as you said, a thorough investigation, including the examination of whether a banksman had been provided and whether that had been ensured by the security employed by my company?
I didn't say I didn't know, I said I didn't recall. What I do recall, if I can refer back to your observation and question that you were making just at the moment, is that the witnesses did make absolutely clear that Mr. Roper did not have a banksman when he was operating his vehicle. In fact, a specific reference was made by one of the witnesses that they could see from a distance that there was no banksman with Mr. Roper.
Plenty of opportunity to put your case as many times as you like, but I'm sure that, as His Honour will tell you in a moment, if you answer the questions I'm asking rather than just simply reciting your statement, we may get through this a little quicker. My point was, Mr. Basharat, is that you did not investigate whether those safety controls initiated by the security consultant or the security guard were in place. Did you?
I did, I just don't recall at the moment.
Would you like to have a look at their statements? I can tell you that you didn't ascertain that they were in place when this incident occurred.
If you believe if that's what the witness statements say, then that is the case. I will concede that.
Now I'm going to pause there because we're running out of time. I think people want to go and have tea and coffee and things in a minute. Can you see where I'm going with this? Yeah? What did I do first? Are you all right?
Yeah, I'm good. Keep going.
Better than sitting there, isn't it?
I've been to acting school.
Well, how do you feel?
Oh, apart from the fact that I know it's not real, from that point of view, if this was real, I'd be sitting there right now going...
Yeah, because what I've done is I've nailed it. I got him to establish, he's been, I can have this barrister, I can have him, go on, give me your best. Thank you, it's exactly what we like.
Yeah.
Because the second you start doing that, I've got you. You're giving you nice long answers. Do you mean yes? Do you mean no? And then what you then do is I then get you to agree to something in place. And then, well, where's this? You said it was part of this. You've agreed all this. There's a bit of doubt creeping in there, ladies and gentlemen. No, nobody's voted yet. But the point being is the doubt creeping in, and that's what you do. I knew where I was going from the minute I stood up. And what I've done now is started to put some doubt into it. I don't know how much time we've got left, and I don't want to take too much time. Yeah, I don't want to be overly long, but this is probably the main witness, and you can understand why. So to try and give a flavour. So I'd have done perhaps this, and by now he would still be reeling on the ropes with a bit of luck in the following win. I'll go straight into number two. You investigated, did you not, this particular site, and there was, as you've already agreed, an induction in place that was perfectly proper.
That wasn't followed, sir.
Sorry?
That wasn't followed.
Now that's your comment. Was there an induction that was in place that was
you've already
perfectly proper?
established that, Mr.
Thank
Collins.
you, Your Honour. It seems the witness didn't seem to want to answer the question. I thought we had. Now, the point is, when was that induction given?
That was not given to Mr. Roper.
No, when was that induction given? I can't make the question any simpler, Mr. Basharat.
So, forgive me, sir,
No, when was it given?
To whom?
Well, that's the question. My learned friend might want him to answer that,
Well,
but I want to know when it was given.
I think that is a question that is meaningless unless you ask the question to whom it was given.
Well, the point is, Your Honour, did you, or perhaps I can ask it this way, Mr. Basharat, how many times was the induction given?
The only individual that I was able to ascertain during the investigation that was relevant to the actual incident itself being inducted was Mr. Boom, who was run over by his colleagues who wasn't inducted.
But are you aware that the induction was given both on the 13th of February, 2 days previously?
I believe Mr. Boom was inducted on the 13th of February. I do not believe Mr. Roper was ever inducted.
Was it given on the 14th?
I believe Mr. Broom was inducted to that site, the injured person, but Mr. Roper, the person who ran him over, was never inducted. In fact, he was offered the induction. He was asked to be inducted.
Was it given on the 15th?
And he was not inducted.
Was it given on the 15th? No, just pause there, Mr. He's not answering the question, is he? He's just trying to put his case forward. You're all getting it, and it's very difficult when you're a witness. The point being, if you don't answer the question, I'll just keep running with it. And we haven't got the time today. I would run with this for half an hour until the judge stops me. Because the point being is, it's important for my case, who was present at that induction? Who was there on the 13th? Who was there on the 14th? Where's your record of who actually received this induction? Was it given to everybody? Was it mostly ignored? These are points that the jury will have to decide as to how it fits into what is operating on this site. We're charged with fairly serious offences. I think we're entitled to put forward our defences. But we're not going to get the answer. I think we're going to have to...
Yeah. Normally now, I'm just going to ask some questions to fill any damage which the prosecution had around building for the purpose of this. We check with 2 more live witnesses before you start winning all of them. So, thank you very much indeed.
Thank you, Mr. Bishop. Yes, Mr. Campbell, your next witness.
Did an induction take place?
Yes, it did.
Did you give that induction?
I did.
Who did you give the induction to?
I gave it to the cabin and fencing contractors.
What was the nature of that induction?
That was full site induction and vehicle movement around site.
Did there come a time on the 16th when you saw a Mr. Roper drive a buggy past the cabin and onto the field?
They did.
As a result of you seeing that, did you say anything to Mr. Woodford?
I did. I called Mr. Woodford and told him that a guy was driving the buggy with no induction.